Hi everyone, how are you all? So welcome back to the channel, and today we are going to have mega concept revision series for the Companies Act, and this is going to be the part 1 of our class. Right, so before starting, just let me know in the chat section if everything is good or not. My voice is clear to all of you, and also the video quality is absolutely fine. Just let me know in the chat section, then I'll move ahead. Right. Okay, and this Companies Act subject is the most scoring subject in your PFRDA syllabus, right? And this PFRDA, so this PFRDA, everything is good? Yes, all good. Okay. So now this PFRDA and also for the SEBI as well, Companies Act is the most scoring and the easiest subject of all. In this, you don't have to apply too much logic. Whatever provisions are there, you just have to remember them, right? So this is what we are going to do in this today's class. And before moving ahead, I just want to tell you this thing, that we are giving you PFRDA decoded syllabus or complete syllabus ebook for free of cost, and the link to download this ebook, you will find it in the description box, right? Okay, and similarly we have this ebook for you for the IFSCA, and this IFSCA ebook contains all the questions and answers of the previous recruitment cycles, that is of 2023 and 2024, and this also you can get from a link that is being given to you in the description box, right? Okay, so let's move ahead with the first question of the day, and I will see who all are going to be giving me the correct answers, right? First question in front of your screen: a private company cannot issue shares through what? So no logic, just the provisions you have to apply here in this question, and you have to give me the answer. A private company can't issue shares through what? Through right issue, bonus issue, public offer, private placement, none of the above. So the question is very easy. See, private company can issue shares through the right issue. There is no restriction on that. It can also offer shares through the bonus issue. It is not going to be the answer again. Now, a private company cannot offer securities through the public offer, because public offer can be given by only the public companies. So C, option number C is going to be the right answer, and I can see everyone is correct here. Cool. Good. Now, this is the section, that is section number 23, which deals with the public offer, and it says that public company may issue securities through public offer, private placement, and right issue and bonus issue. But on the other hand, when we talk about the private company, it issues securities through right issue and bonus issue and your private placement, not the public offer. Cool. Next question, question number 2: for dash companies, matters relating to issue and transfer of securities shall be administered by SEBI. So for which type of companies these matters are going to be administered by SEBI? Tell me what should be the answer here. Option number A, listed companies. Option number 2, companies intended to get themselves listed. Option number C, unlisted companies with net worth of greater than 500 crores. Option number D, both A and B. Option number E, both A and C. And option number F says all A, B and C. So yes, answer is option number D, that is both A and B. So because this unlisted companies is not going to be the answer, so matters related to issue and transfer of securities with respect to the unlisted company is not going to be administered by the SEBI. It is going to be administered by the central government only, right? But for the listed companies and those companies which are thinking to get themselves listed or which are intended to get themselves listed, the matters related to issuance of securities and transfer of securities is going to be administered by the SEBI itself, and everyone is correct. Most of you are correct. Cool. And section 24 talks about this thing, right? It says whatever we have discussed in the previous slide. Next question: when company is issuing securities through issuing house, now company is not issuing the securities directly to the public. What it is doing actually, it is hiring the brokerage firm or underwriters, and through them they are issuing the securities, right? So the question is asking you, the document issued by the issuing house, that is the brokerage house, shall be deemed to be a prospectus. So that document through which this brokerage house is issuing shares to the public, this document will be called as prospectus of the company. But there are certain conditions. If those conditions are fulfilled, then only we can call it deemed prospectus. So the question is asking about that condition. Only if issuing house allots or offers to allot securities within dash days or months of the agreement with the main company. So what should be the answer here? Option number A says 15 days. Option number B says 30 days. Option number C says 2 months. Option number D says 6 months. Option number E says 1 year. So the correct answer would be option number D. Right? And I can see most of you are correct again. That's really good. Cool. So answer is option number D, 6 months. So what happens? This is the section number 85. What happens whenever a company tries to issue securities to the public through the brokerage firm or issuing house? In our case, it is IDBI Bank. Whatever document is going to get issued by the IDBI Bank to the public to issue these shares to them, that document we will consider it as the prospectus. That's called deemed prospectus. But the thing here is, to call it deemed prospectus, there is a condition that must be followed. Condition is, this issuing house must offer or allots this security within 6 months. Within 6 months when it has entered the agreement with the main company. So within 6 months of that, this IDBI Bank is issuing securities to the public. Then we are going to call it as the deemed prospectus. Or the second condition is what? Second condition says whole consideration is not received by the company before offer is made by the issuing house to the public. So second condition says this IDBI Bank, when it is going to issue these shares to the public, then it is going to receive the money and then it is going to give money to the main company. If that is the case, again we will call this document as the deemed prospectus. So the main company is not getting any consideration before this IDBI Bank or before this issuing house issuing security to the public, right? So these two conditions, any one of them is, if any one of them is true, then we are going to call them deemed prospectus. Cool. Next question. No prospectus shall be valid if it is issued more than dash after the date on which a copy thereof is delivered to the registrar. What should be the answer here? A option 30 days, B option 60 days, C option 90 days, D option 120 days, E option 6 months. So question is asking you, no prospectus shall be valid if it is issued more than dash days or months after the date on which a copy is delivered to the registrar. What should be the answer here? Yes, everyone is correct. Answer would be option number C, 90 days. And I can see every one of you is correct here in this question. Very, very good. Right. Okay. Next question. So this thing is being talked about in section number 26. Right. So section 26 says this only, that if you have delivered the copy of prospectus to the registrar within 90 days, you have to publish it, right? Otherwise it is going to be invalid. Okay. Next question. This is repeated. Yeah. Next question. The grievances related to dematerialization of securities by unlisted public company shall be submitted to whom? So the grievances related to the dematerialization of securities by the unlisted company is going to be submitted to whom? Is it going to be submitted to the ROC or is it going to be submitted to tribunal? C option says SEBI. D option says it is going to be submitted to the Investor Education and Protection Fund Authority, IEPF. E option says none of the above. So yes, I can see everyone is again correct. Option number D is the right answer. You are too fast in the Companies Act and I am proud to see that. So option number D is the right answer. Cool. Next question. Next question we have is, question number 6. Every unlisted public company shall submit form PAS 6. Form PAS 6 to the registrar within dash days or months, duly certified by the company secretary in practice or chartered accountant in practice. What should be the answer here? Tell me. What should be the answer for this particular question? A option says 30 days from the conclusion of each half year. 60 days from the conclusion of each half year, and C option says 60 days, 30 days from the conclusion of each year, and D option says 60 days from the conclusion of each year. So let me check the chat section, and yes, again everyone is correct. 60 days from the conclusion of each half year. Now understand the logic. What is this PA6 first of all? So section is section number 29, in which we are talking about public offer of securities to be done in the dematerialized form. So it says that PAS6 is the reconciliation of share capital audit report. So what is this basically? See, this share capital audit report is the report in which you are matching the share capital of the company with the total share capital that is in the demat form. So this is what you are reconciling, right? So every unlisted company is going to submit this form to the registrar within 60 days from the conclusion of each half year. So that means in a year you have to fill this form 2 times, right? And if any discrepancy is there, if any difference is there between the issued capital and the issued capital that is held in the demat form, if there is any difference, immediately it should be conveyed, right? Okay, so the grievances related to these type of companies under this rule will be filed before the Investor Education and Protection Fund Authority, right? This question also we had done. Okay, 7th question, which prospectus is an incomplete prospectus? Very, very important question, because a question can be asked from you in the examination from the prospectus topic. A option says deemed prospectus, B option says abridged prospectus, C option says shelf prospectus, D option says red herring prospectus, E option says none of the above. So what is this deemed prospectus? We have talked about this. So obviously it is not going to be the answer. It is not the incomplete prospectus, it is the complete one. What is this abridged prospectus? Abridged prospectus is that prospectus which is attached with the application form through which the potential investors are applying for our company's shares, right? It is the summarized form of the prospectus. So it is not going to be the answer again. What is this shell prospectus? Shell prospectus is the prospectus which you can issue or which you can use multiple times in a year, right? So also it is not going to be the answer. Then we have the red herring prospectus. It is going to be the correct answer, and let me check. Yes, everyone is, not everyone. Okay, in this question, okay, yeah, everyone is correct. I can see everyone is correct again. Okay, good. So red herring is going to be the answer. Why? Because this is the type of prospectus in which the quantum of securities and the price of securities are not mentioned. Basically, it is the method of price discoveries. So the potential investors or shareholders are going to bid for our shares. Then we will decide what is going to be the price of each share, right? And what is going to be the quantum of securities, that also we are going to decide after the bidding process. So it's called red herring prospectus because quantum of securities and the price of securities is not given in this type of prospectus. Cool. Option number D is the right answer. Next, this is being talked about in section number 32. You have to remember the section number as well. Okay, next question. Shelf prospectus shall be valid for a maximum period of how many days, months, or years? So what is this shelf prospectus? I have told you, just like the book we have, we can use it multiple times. Similarly, if for the first time of issuance of shares, if we are issuing any prospectus, we can use that prospectus, we can use that same prospectus multiple times within dash days, months, or a year. You have to tell me the answer. 6 months, 9 months. C option is next open issue of the same kind of shares, 1 year, none of the above. What should be the answer here? Let me check the chat section, and yes, again everyone is correct. Option number D is the right answer. Cool. So section number is 31. So company is going to file shelf prospectus at the time of first offer of securities, and after that, whatever subsequent offers are going to be offered, company can file the same shelf prospectus with the information memorandum. What is this information memorandum? Basically, it's a additional document that is showing any difference between the previous issue and this current issue. That's your information memorandum. So whatever changes has been done from the previous or from the first issue to this issue, that you are going to show in the information memorandum, right? Next question. The amount payable on application on every security shall not be less than dash % of the nominal amount of security as per Companies Act 2013. So you have to tell me what is the minimum percentage of nominal amount that is payable on application as per the Companies Act. So Companies Act dictate this percentage of nominal amount of security that we must receive from the potential shareholders as the application money. So is it 2.5% or is it 5%? Is it 7.5%? Or is it 10%? Or the answer is none of the above? Tell me the answer in the chat section, and I can see I have started to get the answers. And yes, again, everyone is correct. Answer would be 5% only. Very good, everyone. Cool. So the section number is section number 39, and it says that yes, application money has to be 5% of the nominal amount of the security. But we have got some SEBI regulations as well. So SEBI has prescribed the minimum sum payable on application as what? At least 25% of the issue price. Issue price is different, nominal value is different. You all are aware of that, right, in the accounts. So suppose face value is 10 rupees, but company is issuing it at rupees 20. So this is the issue. This is the issuance price. SEBI talks about the 25% of this 20 rupees, but on the other hand, Companies Act talks about the 5% of this 10 rupees. So both of these has to be followed by a company, right? Okay. So SEBI has prescribed the limit of 25% of the issuance price that needs to be paid on the application, right? And one more limit is prescribed by the SEBI, and that is the minimum subscription in case of equity shares as per SEBI shall not be less than 90% of the issue size. So if the company is coming up with the issuance of 1 lakh rupees of shares, so minimum subscription it should get is 90,000 worth of shares. Then only it will move ahead with the allotment part. Cool. So you have to remember all these three figures. Okay, let's move ahead with the 10th question. Whenever a company makes any allotment, of securities, it shall file with the registrar a return of allotment within 30 days in the form of dash PAS1, PAS2, PAS3, PAS4, none of the above. Tell me what should be the answer here. Whenever a company makes any allotment of securities, it is going to file with the ROC, right? So it is going to file the form. Which form it is going to file within 30 days? You have to tell me the form number. Days are given here. So very easy question. The form is, let me check the chat section. Yes, everyone is correct. PAS3. Cool. Next question. The section number is 39 for this question. Maximum underwriting commission that can be paid by a company for the issuance of debentures is what? Of the issuance of the issue price of debentures. So what is underwriting? You know that now, ki whenever a company is coming up with the issuance of securities, whether it is shares or whether it is debentures, it can hire some brokerage firms. Those are called underwriters. So we have to pay some commission to them, isn't it? Because they are issuing the shares on our behalf, right? So they are taking care of all the legal aspects. So we have to pay commission to them. So what is the maximum commission that we can pay to them? Is it 1%, 2%, 2.5%, 3.5% or 5%? In the case of debenture, let me check the chat section and okay, not everyone is correct here. I am talking about debentures. Here in this question, not everyone is correct. Answer will be 2.5%. Some of you have given me the answer of 5%, but 5% is the limit for the shares, Baba. Yeah, 5% is the limit for the shares, not for the debentures. You have to remember that. So section is section number 40, and see, it is written here. In case of shares, the commission is 5%, but in case of debentures, the commission will be 2.5%. Cool. Next question. If the minimum amount has not been subscribed and the application money is not received within a period of dash days from the date of issue of prospectus, so you haven't got the minimum amount of 90%. So the whatever amount you have received, you have to return it within 15 days. But the question is asking if this application money is not received within a period of how many days, so that you are going to return it within 15 days. If you are not getting the minimum subscription amount within how many days, so that you have to return it. Option number A says 30 days, 60 days, 45 days, 90 days or 15 days. Tell me what should be the answer here, everyone. And I have started to get the answers, and yes, In this question, everyone is correct. 30 days is going to be the answer. So within 30 days, if we are not getting the prescribed minimum amount of the issuance of the issue size, we are going to return that money, whatever we have got till now, within 15 days of the closure of the issue. Cool. Very nice, everyone. Everyone is correct. And the section is section number 39. Next question. Voting power in respect of shares with differential voting rights of the company shall not exceed -% of the total voting power, including voting power in respect of the equity shares with the differential voting rights. Very, very easy question. So it is just asking you, if you are issuing some DVR shares, then the percentage of that DVR shares in comparison with the total voting rights, it should not exceed how much percent of that. So A option says it should not exceed 24% of the total voting rights, or it should not exceed 26%, or it should not exceed 74%, or it should not exceed 76%. What should be the answer? Let me check first of all the chat section. And yes, again everyone is correct. The answer is yes, 74%. Very, very good. Answer is 74%. Section is section number 43. Cool. Next question. To issue the shares with the DVR, a company should not be penalized under RBI FEMA Act during how many years? Option says 3 years, 4 years, 5 years, 6 years. So it is very easy question. You have to tell me how many years is going to be the answer for this particular question. To issue the DVR, a company should not be penalized under any act, RBI, FEMA, or any other act, any other related acts during the last 3 years, 4 years, 5 years, or 6 years. So let me check the chat section first of all. And yes, again everyone is correct. Cool. Very nice. Answer would be yes, 3 years only. Very good. Now next question. In disputed cases, for how many years be the records related to the share certificates be maintained? In the case of dispute, it is asking you, not in the normal case scenario. So in case there is a dispute with relation to the share certificate, for how many years you need to maintain that certificate in your head office or in any office? A option says for 5 years, B option says for 8 years, C option says for 10 years, D option says none of the above, and E option says for the 15 years. What should be the answer? Let me check the chat section first of all. Okay, so I have started to get the answers, and again everyone is correct. Cool. तो कंपनीज एक्ट में तो आप लोग अच्छे हो बहुत, कोई वेरी गुड. सो एवरीवन इज करेक्ट. आंसर वुड बी नन ऑफ द अबव. It is going to be maintained for lifetime, right? Answer is yes, option number D. And section is section number 46. Cool. Very nice. ठीक. So in the normal case scenario, it is going to be preserved for 30 years. In the case of disputed case, it is going to be preserved permanently for the lifetime, right? Okay. And this is your homework question. After the video is over, you have to pause the video, then give me the answer in the chat section. और मुझे ये भी बताना कि आपको वीडियो कैसी लगी. कमेंट सेक्शन में बता देना कि आपको वीडियो कैसी लगी. सारा थैंक यू कमेंट में कर देना, ठीक है? चलो मैं चलता हूँ, और भी काम है. टाटा बाय बाय. ऑल द बेस्ट फॉर द एग्जाम्स एवरीवन.